Good morning.
Good morning.
Good morning, Your Honor.
Morning. Welcome to the First District Court of Appeals. So the first case that we have scheduled for argument today is case number C210343 and 353, City of Cincinnati versus City of Cincinnati versus State of Ohio, City of Cincinnati. If parties can please identify themselves and their readiness to proceed.
Shannon Price, Your Honor, on behalf of the City of Cincinnati, and we are ready to proceed.
Kurt Hartman on behalf of the appellee and cross appellant Tom Brinkman, and we are ready to proceed.
Okay. Attorney Price, would you like to reserve time?
Yes, Your Honor, we would like to reserve 4 minutes for rebuttal.
Okay. And Attorney Hartman, would you also like to reserve time?
Yes, I'd like to reserve 2 minutes on my cross appeal.
Okay, wonderful. Whenever you're ready, Attorney Price.
Thank you. May it please the court. This is a case about the function and separation of powers in local government, where Mr. Brinkman has sued the solicitor's office for failing to exercise a power that, according to him, we don't even have. The trial court's reading of the charter and the statutes at issue here works absurd results, and we ask this court to reverse for 3 reasons. First, because the broad language of the Cincinnati City Charter grants the solicitor an administrative authority to file suit. Second, because the state statutes at issue here, when construed properly and in their context, support this authority. And third, because the Cincinnati city manager, who is under the charter the highest executive authority for the city, approved this specific lawsuit pre-filing. Now let's start with the language of the charter. The relevant provision is housed in Article 4, titled Executive and Administrative Services. It reads that the solicitor shall serve the mayor, council, officers, and boards of the city as legal counsel and attorney, and shall represent the city in all proceedings in court. The language we really need to hone in on here is to serve the city as legal counsel and attorney. There's no distinction in that language between serving as legal counsel by initiating suit and serving as legal counsel by defending suit. And for good reason, because in practical reality, to serve as effective legal counsel, the solicitor has to do both of those things. And that dual authority is contemplated by the state statutes here. The trial court honed in on 733.53, under which the city council may, if it chooses, direct the solicitor to file suit or defend suit in certain circumstances. But what the trial court, where the trial court made a mistake is in ignoring the language of other state statutes, including RC 733.56, 0.57, and 0.58. These statutes, each of these statutes, imposes a mandatory duty on the solicitor. The solicitor shall file suit if one of these things occurs. But they make no mention of the legislative authority of the city. And that's because the legislative authority of the city doesn't have to provide pre-approval for the solicitor to defend the city's already existing rights. And that's what we did in this case. And this case is about a constitutional challenge to RC 9.68. Specifically, we were challenging whether or not the statute was in violation of the city's home rule authority. This home rule authority exists independently of any action by council. It has to. It comes from the Ohio Constitution itself. And the solicitor is tasked to defend the city's constitutional rights, among other interests. We have to be able to bring this type of suit when council is in recess, when council is divided, when, for example, there might be tension between the council and the manager or the council and the mayor. It is the role of the administrative branch and of an administrative authority like the solicitor to step in these situations and to protect the city's legal interests. And that's what we did here.
Ms. Price, or Attorney Price, you said there's certain circumstances where council must act either by resolution or statute. And what would those circumstances be?
For example, council may create a new type of ordinance. One of the examples cited in the briefs here is actually an anti-dumping ordinance. So council might, in its discretion, choose to pass a new law that prohibits certain types of dumping. And it might also then instruct the solicitor to prosecute those types of claims. That's a perfectly ordinary exercise of legislative authority. And it makes sense that the solicitor or that the council has to tell us, is this a civil offense? Is this a criminal offense? Is there an administrative appeals process? But the fact that council can, in its discretion, pass an ordinance and instruct the solicitor to enforce it in a particular way, in no way means that the solicitor can't act independently. Because many of the city's rights precede and, in fact, supersede the council's authority, because those rights come from the Ohio Constitution and from state law. So far as your honors would like to discuss the cross appeal, the city's position is that to rule for Mr. Brinkman here, this district would have to create a district split, because there are 3 districts that have already ruled squarely on the issue of declaratory relief under RC 733.59. And there's no need to do that, because as the trial court correctly found, there's no language in RC 733.56, 0.57, or 0.58 that authorizes declaratory judgment. Those statutes outline the specific forms of relief that are available to respondent, and he is limited to those specific forms of relief. There's actually a good contrast here that we can look to with the statute underlying the case, RC 9.68. There in 9.68b, the Ohio General Assembly chose to explicitly say a plaintiff may seek injunctive relief, damages, declaratory relief. The General Assembly knows how to instruct when it's writing a statute that declaratory relief is available or is not. And under RCC 733.56, 0.57, 0.58, 0.59, the General Assembly chose not to instruct about declaratory relief. And so it is not available. I'm returning to my third point about the separation of powers and function of Cincinnati government here. It's also crucial for this court to note that there is no dispute in the record whatsoever about the involvement of the city manager in today's case. The city manager is the highest executive authority of the city of Cincinnati and plays a key role in the system of checks and balances that we have here. If the solicitor was to file suit in a way that the city manager disapproved of, the city manager can remove the solicitor. It's that simple. If the city manager and the solicitor were to take action that council disapproved of, then council and the mayor can take steps to try to remove the manager and the solicitor. We have checks and balances here. We have a removal power that has traditionally been in all levels of government, the way that the legislature keeps an eye on the executive and the administrative. But what happened here was that the solicitor got explicit approval from the city manager to file this suit. And then it was filed. There's no dispute in the record that that is the procedure that we undertook. And that alone is enough to justify reversal of the trial court, which failed to consider the issue of the city manager's involvement at all. Unless your honors have further questions, I would reserve the remainder of my time for rebuttal.
Thank you.
Thank you.
Attorney Hartman, whenever you're ready.
Thank you, Your Honor. May it please the court. In 1999, the city of Cincinnati sued various gun manufacturers. And in that situation, this court, the first district, was again called upon to address the authority by which that action was brought. And in the case of State XRL Winburn versus City of Cincinnati, Judge Heekin relied upon it and cited to in footnote 39 of his opinion. This court said, it is unquote, it is undisputed that the city followed the proper procedure when instituting that lawsuit against the manufacturers of firearms. A motion to file the lawsuit was brought before the Cincinnati City Council, debated, put to a vote, and passed by a majority of council members. The ordinance included an appropriation of $100,000 to pay for cost and expense of the proposed litigation. After passage of the ordinance, the city filed the lawsuit. That's the way that it operates. What we have now is an administration in the city of Cincinnati that has sought to ignore the power and authority and rights of the Cincinnati City Council. Because in their brief, if you look in their brief at page 4, the city actually argues that the city solicitor has, quote, unlimited authority, close quote, to initiate lawsuits on behalf of the city. Unlimited authority. That's what they've argued. And what they do in order to justify that is they have ignored fundamental principles of statutory construction, both as it applies to the Cincinnati City Charter and as it applies to state law. First and foremost, when there is no conflict between a charter and state law, it is the duty of courts to harmonize those provisions. And in the response brief, the city actually acknowledges that there is no conflict between the charter and state law. Yet they tend to ignore the state laws, specifically 715.01 and 715.03. So that this court first and foremost has to do is harmonize those provisions. The second principle of statutory construction that the city conveniently ignores is that it's the duty to give effect to the words used, not to delete words used or to insert words not used. And in this case, the city constantly is engaging in that when they point to the city charter, but they point to the administrative code, and they say that, and they contend, and I'm quoting out their brief at page 4, this code, quote, unequivocally provides the city solicitor with unlimited authority to initiate lawsuits on behalf of the city, close quote. There is no language in the charter, in the administrative code, that provides that the city solicitor has any authority, let alone unlimited authority, to initiate lawsuits. So that then what we have to look at, you give words to the effect, there's no authority under any rule of statutory construction to add to, enlarge, or expand the provisions of a statute in order to meet a situation not provided for. Yet that is exactly what the city wants you to do, is to ignore city council. Because if you look at the revised code, section 715.01 grants the various powers, including the power to sue corporations. And then 7.03 says not only how the power to sue is to be exercised, but how all the powers granted in chapter 715, from 715.01 to 715.67, how are all of those powers to be exercised? By the legislative authority, by ordinance or resolution. That is what it says.
Attorney
Yes,
Hartman, I have a question, and this isn't exactly related to what you're talking about right now, but
Okay.
if we were to rule in Mr. Brinkman's favor, what is the effect, if any, on any past lawsuits in which the city council did not pass an ordinance before the law director filed suit?
I think that's somewhat water under the bridge. I mean, the issues were not raised. There was not an issue raised, so it's somewhat waived, I believe, in those situations. We have now a taxpayer lawsuit who is challenging the abuse of corporate powers and the expenditure of city funds. So he went through the conditions precedent to bringing this lawsuit to get the issue before the court. I think it would be apt for any defendant on a city lawsuit to challenge that, yes, going forward. But not for stuff that's already occurred. I think the issue's been waived in other cases.
Okay. Then my next question for you. So being that the city law director is under the executive branch of the city government, would this threaten the separation of powers?
No, it doesn't. Because innately and at common law, the power to sue is in the first instance a legislative prerogative. And again, it's exercising the powers of the municipal corporation. And the question is, which branch exercises the municipal power to sue? And as set forth in chapter 715, specifically 715.03, that power is the legislative authority. Because if you look at it, not only in that Beretta case that I cited to that this court found that they did go through the proper procedure, but another principle of statutory construction that the city ignores is that, one, under a home rule municipality, consideration may be given to the interpretation of the provision by how they've operated under it. And that a legislative body, be it the state legislature or the city council, is not presumed to do a vain or useless act. In our complaint and in our brief as our appendix, we've attached 6 pages of numerous provisions within the Cincinnati Municipal Code, where the Cincinnati City Council has explicitly provided an authority for the law director or the city solicitor to bring a lawsuit. But usually there's conditions preceded. I look at, like, for example, section 1201.-41 authorizes the city law director to bring a lawsuit on application from the fire chief for a violation of the fire code. And you look at all those provisions in there, if those provisions, you accept the argument that the city solicitor is arguing that he has unlimited authority to bring a lawsuit with no play or no interaction from Cincinnati City Council, or no authority from Cincinnati City Council, why are all those provisions in the municipal code? Because the way the city is operated, and maybe back in the days of Charlie Taft or Ted Berry or whoever, they understood the proper relationship, that the prerogative of spending taxpayer dollars to pursue litigation has to, in the first and foremost instance, be a legislative act, because that is the accountability that the voters and the taxpayers have. The way the city would have it is unaccountable bureaucrats bring the lawsuit, but under state law, under 715.01 and 715.03, the exercise of the municipal powers is done by the legislative authority, and it must be done either by ordinance or by resolution, not by motion. And that's the distinction that 715.03 makes. And so you look at that. Why did the legislature put 715.03 in there? Because if you look at the argument that the city makes, you could repeal that entire provision and it has no effect whatsoever. It doesn't change the status quo, according to the city. Again, their whole argument is that legislative bodies, be it the General Assembly and Cincinnati City Council, have repeatedly done vain and useless actions in passing legislation. That is a fundamental, well-established principle of statutory construction that they are arguing to be violated. I would say, in terms of the, they do reference 2 cases, the Farland and the Toledo case in their decisions. But again, those cases are clearly distinguishable. The Fairland versus Fraley case out of the 9th District, an unpublished decision from 1991, never even addressed this question. The argument was made, but it was posited as a matter of subject matter jurisdiction, and the court simply considered it as a question of subject matter jurisdiction and said, we have subject matter jurisdiction on these type of lawsuits. It didn't address the authority of a city law director or city solicitor to bring a lawsuit. In the Toledo case from the Supreme Court, again, that issue was not raised in terms of a city solicitor bringing a lawsuit. The 2 questions, over the one predominant issue as identified by the Supreme Court was whether the city of Toledo was authorized to institute a mandamus action. That's what the question was before the court. Yet the city wants to go far afield and start reading, again, more stuff into that decision. But again, we cite to it in our reply brief at page 6, the note 3, that issues not raised or briefed before a court and not part of the decision of the court are not binding precedent. And so in that case, those 2 decisions, I think, are clearly and really distinguishable. One was simply a question, or they treated the question before the court as subject matter jurisdiction. And the second of all, whether a municipal corporation could bring a mandamus action, not who had the authority to bring that mandamus action on behalf of the city. In terms of the cross appeal, in terms of declaratory judgment, we've set forth clearly in our brief, and the city kind of ignores it. The Porter decision from the Ohio Supreme Court, it's interesting, they argue you should ignore Porter because it's quote unquote outdated. There is never a principle in law that says an outdated decision is not binding precedent on a lower court. Under their argument, Marbury versus Madison would be outdated because it's over 200 years old. This court's not going to ignore that decision, nor can it just ignore the Porter decision. Additionally, the Smitherman decision from this court actually upheld the ability to bring a declaratory judgment claim in conjunction with a statutory taxpayer action. One final thing I would point out, the city makes much ado in their reply brief about, well, the taxpayer lawsuit provisions, et cetera. We'd have to run to city council to get permission to do there. Again, principles of statutory construction undermine the city's argument. The general provision is in 715.03, i.e. that city council legislative authority is required in order to exercise the power to sue. The more specific provision is in 733.56, the statutory taxpayer action. And the principle of statutory construction there applicable is when you have a general and a specific provision in conflict, the specific controls. And so the statutory taxpayer provision that authorizes a city law solicitor to bring a taxpayer lawsuit is specific. That would govern over the 715.03 provision. And it's interesting, she said it's mandatory, but interestingly, city solicitor did not bring this taxpayer lawsuit and does not regularly bring taxpayer lawsuits, and leaves it to taxpayers to vindicate the public interest and to challenge or control the abuse of corporate powers and the illegal expenditure of funds. So at the end of the day, this is simply a matter of a lot of statutory principles or maxims of statutory construction that go into play. And it is who has the power to sue. There's no conflict between the charter and state law. State law clearly gives that power to the legislative authority to be acted upon by ordinance or resolution. In this case, the city has not done so, refuses to do so. It's interesting, there was another case recently where the city actually did go back and get authorization from city council for another lawsuit. So what is it? It's not in the record, but they kind of have this argument of convenience. 1999, they did it the right way. In the Beretta case, they went to city council. They debated it. There was a debate. There was a vote to do it. There was a vote to authorize the expenditure of public funds. That is a legislative prerogative. The legislative prerogative also goes to the exercising the various powers, not just the power to sue, but the various powers in revised code 715.01 to 715.67. Because again, as I argued in our reply brief, we cannot limit it just to the question of power to sue, the state law provisions. You got to look at all the provisions and how they're exercised. The city solicitor.
Hartman, you have about a minute left.
Okay, I'll just say the city solicitor does not have unlimited authority, free from any oversight, free from the council, especially the power of the purse, to do any litigation he or she thinks he wants to do. We'd ask the court to affirm on the appeal and to reverse and say we do have the right to declaratory judgment on the cross appeal. Thank you, Your Honor.
Thank you. Attorney Price.
Thank you, Your Honor. I'd like to start with the point that Judge Bach made about the separation of powers. Mr. Brinkman's reading of the charter and the statutes here does directly threaten the separation of powers in local government because it seeks to elevate the city council as the sole client, supervisor, and manager of the solicitor, an official in the executive branch. Going back to the language of the charter here, the solicitor shall serve the mayor, councils, officers, and boards of the city. Council is not our only client, nor is council under the charter our manager and supervisor. That goes to the city manager, the head executive official. I'd also like to talk a little bit about Mr. Brinkman's characterization of the power to file suit. He views it as a legislative power, but under this court's case law, that's just not right. Filing suit to enforce laws already in existence is an executive power. And the case I'm referencing here is actually State ex rel. Langhenry v. Britt. And that's referenced in the briefs here. That's one of this court's cases. And it outlines the fact that when you're enforcing the laws, you're acting in your executive capacity. That's what the manager and the solicitor do. So far as the statutory language here, I do think we need to get a little bit more into the words used in 715.03 and 733.53. So I'll start with 715.03. Yes, that statute gives council the ability to direct the activities of the solicitor, but it uses an absolutely critical word to describe that ability. It uses the word may. because the legislative may direct the executive in some circumstances. But that doesn't mean that the executive cannot act absent an explicit instruction. As for 733.53, this is where we need to start looking at the Ohio Supreme Court precedent in State ex rel Toledo. Yes, the language in the Cincinnati City Charter is different than the language in the Toledo City Charter, but the language interpreted by the Toledo court is actually identical to the language in RC 733.53. The State ex rel Toledo court interpreted that language to prosecute or defend broadly. They said that that language has to mean that the solicitor has an administrative authority to file suit. That's the language, the exact language that Mr. Brinkman says means the opposite. And it's the city's position that this court is actually bound by State ex rel Toledo to interpret 733.53 broadly and to find that it grants the solicitor this administrative authority. I'd also like to return to another point you made, Judge Bach, about prior lawsuits. The trial court and Mr. Brinkman both cite to a specific 1999 lawsuit. That's the Winburn suit, where counsel and the solicitor worked in tandem to bring a politically very significant suit. But tellingly, counsel can't cite to any more recent suits where this happened. One case from 1999, where the city followed one specific procedure, does not create a legal imperative for the solicitor in all circumstances. Sometimes it makes sense from a political standpoint for the solicitor, the manager, the mayor, and council to make a public statement that they are all on board for pursuing a particular type of litigation. But that political reality doesn't change the language of the charter, doesn't change the language of the statutes. And neither the charter nor the statutes require us to get council approval before filing suit. Much has been made in the briefs and in the argument today about the supposedly unlimited authority at issue in this case for the solicitor. And that just isn't the city's argument. We don't have unlimited authority because we are subject to supervision and removal, ultimately, by the manager, the mayor, and council. Rather, the city is arguing and the solicitor is arguing that we possess discretionary authority to enforce the laws as we see them. And if the manager doesn't like how we're doing it, the manager can remove the solicitor. If the council doesn't like how the manager and the solicitor are proceeding, then the council can move to remove the manager. There's no unlimited authority here. It's simply not at issue. Rather, what is at issue is the proper separation of powers between the legislative authority, which is one but not the only client of the solicitor, and the executive branch. As for principles of statutory construction, we just cannot emphasize enough the absurd results that the trial court's construction would work for other state statutes at issue in this case. The trial court honed in on 733.53, and it interpreted that statute to impose a mandatory duty, despite the absence of language in the statute that actually does so. But if you read 733.53 this way, if you read this discretionary ability of counsel as a mandatory prerogative, then you obliterate the framework at 733.56, 0.57, 0.58, 0.59, as well as other statutes, although those are the ones at issue in today's case. The solicitor has to have this administrative authority to initiate suit in order for the taxpayer statutes to work. Yes, we're not often going to choose to sue ourselves, as counsel suggests, but there is that mandatory duty there. And that mandatory duty can come into play, for example, if one of the boards of the city or council undertakes an action that the solicitor does genuinely view to be an abuse of corporate power, to be in violation of one of the city's contracts. There are many scenarios where the solicitor is going to have to file suit. And we address this in our reply brief, but it's
left. You have about
sorry, Your Honor, I can't hear you.
You have about a minute left.
Thank you, Your Honor.
Okay.
In order for the very, very diverse array of interests that go into governing a city to function together, there has to be an independent administrative oversight that allows the solicitor to enforce the city's rights as they already exist. And that's what we did in this case. And for that reason, we ask this court to reverse the trial court and to find that because the city manager approved this lawsuit and because the language of the charter gives us a broad authority to act as legal counsel, the solicitor does have the ability to initiate suit on the city's behalf without explicit pre-approval. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission. Oh, I'm sorry. We still
Can I get
have
my-
two. Yes.
That's
thank
why
you.
I was, thank you. I was.
Thank you. Thank you.
Thank you, Your Honor.
I'm going into automatic pilot mode.
I understand. It's interesting. The city is constantly changing course in this case for the situation at hand. It's nice, finally, the city solicitor here in argument basically acknowledged that the city solicitor does not have unlimited authority, even though they argued that to this court at page 4 of their appellate brief. And it kind of in her conclusion, though, she kind of reverted back to that, saying the city solicitor has authority to bring a lawsuit without any pre-approval. That is unlimited authority. The second thing, it's interesting, they also changed position in terms of the Toledo case. They argued to this court that there were similar municipal charter provisions. Here in oral argument, she finally says, acknowledges, yes, the charter provisions are different. Again, it's this moving target trying to avoid the underlying issue, which is the law. And the law is under 715.03, the power or the authority to exercise the power to sue, as well as numerous other municipal powers, is granted in the first instance by the revised code to the legislative authority, the Cincinnati City Council. And City Council has done that on numerous occasions, exercised that authority. They did it in the Beretta case formally for a politically charged case, such as this case as well. But in their municipal code, repeatedly, the code, they do it, give authority without needing to run back to City Council on every situation. They say if situation A occurs and the director of buildings request, the city solicitor is hereby authorized to file a lawsuit. That's all that's needed. But it's an accountability issue. And accountability goes to the legislative, the elected body first and foremost. And so that's the issue. You know, finally, in terms of they like to hook on to the word may. And again, matters of statutory construction, you don't isolate a single word. As we argued in our reply brief, the issue is really may by ordinance or resolution, therefore excluding it by motion. There's 3 ways that city governments can operate: resolution, ordinance, or motion. That simply provides that the exercises of all those powers in 715.01 to 715.67 are exercised by the legislative authority, and they can be done by ordinance or resolution. I encourage the court, look at the various provisions, harmonize them, make them compatible, and also construe them in conformity with various principles and maxims of statutory construction. Under that situation, it is clear the authority is to the Cincinnati City Council must give authority, as they have done in the municipal code in that several instances, but they did not do it for this case. And we are entitled both to the injunction that Judge Heekin granted, as well as the declaratory judgment action, because it is consistent and binding precedent of the Ohio Supreme Court Porter case, a decision the city elected to ignore here today.
Thank you.
So therefore, we'd ask for the relief we asked for earlier. Thank you, Your Honor.
Thank you. Thank you both for your arguments this morning. We will now take the matter under submission and issue a timely decision, and we wish you both a wonderful afternoon.
Thank you, Your Honor.
We thank the court. Thank you.
Thank you. Good morning.
Good morning.
We now have Case number C210310, State of Ohio versus Milan Roberts.
Your Honor, I think that might be we are here, Rick Carlson et al. V. City of Cincinnati.
Okay. Has this case submitted on the briefs?
Yes,
Your
Your Honor.
Honor.
No,
I
I'm not
believe-
asking, I'm not asking.
I'm sorry.
Do the judges know? Has
Roberts
Ohio-
is submitted.
Roberts is submitted. Thank you. Okay. So we have case number C210238, Rick Carlson versus City of Cincinnati. If attorneys can please identify themselves and their readiness to proceed.
Erica Faubourg, ready to proceed, and I will request 5 minutes for rebuttal.
Thank you.
Jonathan Hilton for appellee Rick Carlson, ready to proceed.
Thank you. Attorney Faubourg, whenever you are ready, you can go ahead.
Good morning, Your Honors, and may it please the court. Erica Faubourg on behalf of appellant City of Cincinnati, and I have requested 5 minutes for rebuttal. Your Honors, the city appeals the trial court's decision to strike the amended lien release that was filed by the city after this court September 30th, 2020 decision in the same matter. The amended release was filed to ensure the accuracy of both the public record and the legal obligations between the city, appellee, and his daughter, Daisy Carlson. The correction was necessary due to my clerical error. We ask the court to reverse to avoid the unjust result of appellee obtaining a $100,000 windfall solely as a result of a typo. Alternatively, this court might revisit its prior determination that appellee's initial appeal was moot and remand the matter back to the trial court with instructions to enter a modified judgment if necessary, consistent with that prior decision. Your Honors, this appeal is unique in that the parties are in almost complete agreement. We agree the city received 5 judgments at summary judgment. 1 related to appellee Rick Carlson, 1 for his daughter Daisy Carlson, 2 for his other 2 children, and 1 for his corporation. And that each of those judgments got a unique identification number, a CJ number. Second, we agree that those judgments were appealed to this court and that on appeal, this court largely upheld the grant of judgment to the city. We further agree that Ms. Daisy Carlson requested to negotiate a release of her lien, that the parties negotiated that release, and that the satisfaction of judgment, the lien release that was filed by the city, accurately identified that unique CJ number, but inaccurately listed the name of her father, Rick, and not Daisy Carlson. We further agree that during argument on the initial appeal, this court sua sponte raised the question as a result of that typo as to whether appellee had waived his argument. And the counsel during that prior oral argument confirmed that no, that judgment had not been released. Finally, we agree that upon the release of the September 30, 2020 decision, counsel for parties became aware of the typo. The city filed its amended lien release to correct that typo and also filed an application for reconsideration with this court. The counsel for appellee then also filed a motion to stay the effect of the
Now,
amended
that
release.
was filed, I just want for clarity, that was filed after the oral argument, is that correct?
Correct, Your Honor. That was filed after we read in writing the determination that this court made that Mr. Rick Carlson's appeal was mooted by virtue of the lien release. During oral argument, we did not go back and check. I will say that the CJ number is what drives city operations, and it's my understanding that it is also what drives courthouse operations. So we likely would not have caught that error.
And the CJ number was correct in the.
Correct, Your
Is
Honor.
that right? It was the name, the party.
Yes, Your Honor. And,
Okay.
you know, by way of example, currently, I recently looked, Mr. Rick Carlson has approximately 15 CJ numbers associated with his name, which is why that number becomes the most significant
Okay,
piece of data for the debtors and the creditors with respect to judgments.
so let me ask you this, had the Court of Appeals not made the determination of saying, hey, this is mooted out because of this entry, let's say that that was not in the decision.
Correct, yes.
What would be the authority that governs the correction of the entry at issue here that we're talking about?
Your Honor, I have not been able to find a case that speaks to this. I do believe that as an officer of the court, upon recognizing a flat error, inaccuracy in something I have filed with the court, have an affirmative obligation to correct that. And my obligation with respect to candor to the tribunal would require that I take those steps. I do believe that if you flipped that, if, for example, I had a typo that, Ms. Daisy Carlson's judgment was $16,000, it would also be in everybody's interest for, upon recognition of an error, to take those affirmative steps. So I think it is within the inherent authority of the parties and our obligation to make sure that the public record is correct, but also that the trial court or this court at any time can recognize where here we have no dispute with respect to the facts, a Scrivener's error should be corrected.
Okay,
The trial court expressed sympathy during oral argument, recognized that the city made a strong case on that point. It just felt its hands were tied. It
well,
also,
I want to go back to my question and now ask it a little bit differently. What is your position with regard to Civil Rule 60B as to whether that governs the correction of the faulty entry?
Your Honor, at this point, we did move immediately under this court's local rules with respect for reconsideration. What is so distinct in this case is that at the same time as the city was trying to make this correction, appellee filed a motion to stay the effect of the amended lease. So when the court denied both the application and the motion to stay, at that point, the city's interpretation was that this court had ratified the filing of an amended release and deemed that it was unnecessary to go back and revisit its prior determination because on the initial appeal, all substantive arguments had been addressed. So to answer your question, Your Honor, I'm not clear that in this very unique, specific situation that 60B provides the avenue moving forward. That said, the trial court, stated explicitly in its entry striking the amended release that it felt that the city and Ms. Daisy Carlson should be relieved from this unjust Scrivener's error, but that it felt its hands were tied and that it was bound by the law of the case doctrine because the initial determination as to whether the appeal was moot was made by this court. But in contrast, the city's position is that such errors not only should be, but they must be corrected. And that the law of the case doctrine has never stood for or precluded correction of undisputed factual inaccuracies. And indeed, the Ohio Supreme Court in Hawley v. Ridley stated, the law of the case doctrine is, quote, a rule of practice rather than a binding rule of substantive law, and will not be applied so as to achieve unjust results. For those reasons, the city asked that this court reverse the trial court's decision to strike the amended lien release and affirm that the city's judgment against appellee has not been released. And unless your honors have additional questions, I reserve the remainder of my time.
Thank you. Attorney Hilton, good morning again. You can start whenever you're ready.
Good morning. Well, thank you, Your Honors. I guess I'll start by addressing the question that Judge Zayas just asked, which is what is the mechanism for correcting the record? And I think this is important to my client's case because I believe there are mechanisms, but At this point, they either haven't been used, so they're not before the court, or they've been precluded by the procedural posture. So I think that the first way that the city was supposed to correct the record, and which it did try to do, was through Appellate Rule 28 governing reconsideration. So the city did, when it received the opinion of this court, file a motion for reconsideration, or an application for reconsideration, I believe it's called. But that application for reconsideration was denied. At the point of that denial, so the city takes the position that when it received the opinion denying its application for reconsideration, it subjectively believed that it won. I don't see that as a reasonable interpretation. If the court issues a line saying that your application for reconsideration is denied, that does not strike me as having prevailed on the merits of that application. Further, if that had been the case and the application for reconsideration had actually been granted, then my client's appeal, Mr. Carlson's appeal, would have no longer been moot. So the court then probably, would have had to revisit those issues and issue a new substantive opinion on those issues. And that was actually something in the city's application for reconsideration. They said if our motion is granted, we would stipulate that Mr. Carlson should prevail on that issue of $3,500. But the court never reached that issue. It never addressed it because the court denied the application for reconsideration. So at that point, the city's remedy was to appeal to the Ohio Supreme Court. As we've pointed out in our brief, it did not do so.
Mr. Hilton,
Instead, when—
Mr. Hilton,
Yes.
I understand what you're saying, but at that point, the record said that Mr. Carlson's debt had been satisfied. There was a satisfaction of judgment in his name. So at that point, the record could not have been changed to have that particular document say, no, the satisfaction of judgment was for Daisy, not for Rick. So the facts have changed since that point. So how could not appealing to the Supreme Court preclude relief now, since the facts have been amended?
Okay, so I think that's a very important question, and it's actually a little bit technical, but I want to go into what was the legal effect of the notice of satisfaction of judgment that was initially filed, and then what was the effect, if any, of that amended notice of satisfaction. So case law on this issue is somewhat sparse, but the point is that where a notice of satisfaction of judgment, and I'll start with a general rule. The general rule is that a notice of satisfaction of judgment may be unilaterally amended by a party. A party is free to do that. If they file one, they file that notice and they notice an error, they're free to file an amended one. However, there's an exception to that rule that says when a notice of satisfaction of judgment has been intertwined with a court decision, then you can't unilaterally amend it because that would undo the effect of that court ruling. So you have to file, for instance, a Rule 60B motion, or as was the case here, this Rule 28 application for reconsideration. So the notice of satisfaction of judgment that was the amended one was actually just a nullity. And the fact that it was simply a legal nullity is why, it ended up being stricken from the record, because you can't do that. You can't unilaterally file one of those amended satisfaction of judgments when it's been intertwined with a previous court decision.
Isn't that what we're here to decide?
Well, Your Honor, it is, but my authority for this proposition is the In re Dabble case. I believe that that's from the 3rd District. So again, sparse case law. and I appreciate your patience. I'm doing my best with the authority that exists. I'm trying to rely on what authority is out there.
Thank you. Was there anything further?
Yes, Your Honor. So I did just want to mention a few things. One is motions to strike are governed by an abuse of discretion standard. So the standard of review is, did Judge Wagner abuse his discretion in applying the law of the case based on all of the factors that have been presented? And I think Judge Wagner got it right. Perhaps the outcome would have been different if it had been a Rule 60B motion, but as it stood on the facts, I think Judge Wagner got it right, and I certainly don't think it was an abuse of discretion.
Now, if as a matter of law of the case does not apply, that would be an abuse of discretion. Is that correct?
Well, Your Honor, I think that the trial court has to decide in the first instance whether or not to apply the doctrine. So I actually think application of the doctrine itself, whether or not the doctrine should be applied, is actually a mixed question of law and fact. So that would reside, that discretion would still reside within the trial court. If there was something that was a clear misstatement of law that the court relied on in deciding to apply that doctrine, then certainly that could be a narrow, for instance, if the judge had, relied on a statute that was misworded, or the judge misquoted a statute, for instance, that would be a clear mistake of law that would constitute an abuse of discretion. But in this case, it's the trial court's initial decision to apply the doctrine. And that's actually based on public policy matters. So important public policy matters that the trial court could factor in include things like the finality of judgments, whether attorneys should be bound by what they sign, even the question of should the record be read objectively based on what is in the record, or rather should these kinds of things be read subjectively. So I think that discretion does reside within the trial court.
Thank you.
Mr. Hilton, I just want to clarify one question. I just want to make sure that I'm understanding. There is no dispute that the city wrote the wrong name, correct?
At least, I couldn't point to anything to dispute that it was anything other than a clerical error.
Okay, so Daisy has satisfaction of judgment. So I mean, I guess what I'm asking is, there's no dispute that Mr. Carlson owed this money, and there had not been a satisfaction of judgment but for the error.
Well, right. So the $8,700, Rick Carlson paid that, and at the time, the subjective belief of the parties was that this was to release Daisy Carlson. Now, when the court actually addressed this and Carlson won, it took a different approach and looked at the notice, say, objectively by what it said rather than what the parties intended. So the question really hinges around should the court continue to stay with the objective approach rather than just what the subjective party's intent was.
Thank you.
Attorney Hilton, it seems to me that the flip side to, if we were to find your argument to be the correct argument, is that Daisy has not satisfied her judgment.
Yes, Your Honor, and this has been something that has been brought up in the prior litigation in front of the trial court. So I also represent Daisy Carlson. My clients have signed a conflict of interest waiver. They have worked this out among them. I have full authority to say on behalf of Daisy that she will not be prejudiced and does not consider herself prejudiced by that result. If you think about it, actually, it was Mr. Carlson, Rick Carlson, who paid the $8,700 on behalf of his daughter in the first place. It was as a favor to her. It wasn't out of obligation. So that was.
Nonetheless, I think that, the flip side of this is that Daisy has not satisfied her judgment.
Yes, Your Honor.
So if we were to accept that this entry becomes law of the case and governs the satisfaction of Mr. Carlson's, of Rick Carlson's judgment, it also operates to determine that Daisy Carlson has not satisfied.
That's correct. But one good thing about that is that it is consistent with everything in Carlson 1, because when the court initially evaluated the merits of the appeals, it did address Daisy's arguments on appeal. It did not hold initially that Daisy's appeal was moot. So she won't have been prejudiced in any way. And it's consistent with the court's prior opinions. So it would operate in that way, Your Honor. But it doesn't prejudice Daisy. And in fact, if Daisy had felt that she had been prejudiced, then when the city filed its notice of satisfaction of judgment with respect to Rick, she could have then filed something to correct the record herself. Rule 60B motion, Rule 60A motion, even just a motion to strike the other lien release, a motion on her own behalf to satisfy the judgment. She has not done those things and has instructed me not to do those things. So she had ways to defend her rights in that sense, and she's not moving down that route.
Attorney Hilton, you still have 2 minutes for your argument. Would you like to rest?
Well, are there any other questions of the court? I'm here to try to be as helpful as I can. I know it's a very unusual case. And I guess my conclusion in all this is they say hard cases make bad law. And I know there is a natural tendency, and it's something I have myself personally, to feel like, well, gee, this, why should the attorney, my learned friend on the other side, why should her client have to suffer the consequences of what she signed and put into the record? It's a natural tendency, but I think that at the end of the day, the arguments of my client, they involve a lot of case law. They look at a lot of rules. They consider a lot of legal angles. And if you compare it to the city's briefs, it's a plea for mercy. But I would urge the court to analyze this under the rules and the mechanisms and procedures of the rules, because simply giving in to that tendency to just want to side with the party that you might feel intuitively has been wronged. Hard cases make bad law, and I don't see how a decision in this case is going to establish good precedent for other cases if the court were to rule in the city's favor.
Thank you.
Thank you.
Briefly, Your Honors, and I think this dovetails directly with that point. The Hawley case cited by Appellee states specifically that this doctrine, the law of the case doctrine, should not allow unjust results just for the sake of inconsistency or just for the sake of consistency. It is appropriate to go back and right wrongs of the past. That is what we do as lawyers. But the other case that he discussed today, the Inree Double case, I do think that case is extremely specific. It related to a question of family law where one party wanted to go back in time 20 years to change a satisfaction of judgment that would also have changed the legal relationship between them and another family member. It would change their guardianship 20 years down the line, which is incredibly different from the case before the court today, where we're talking about a typo, where a name was transposed. And Your Honor, to your question previously, perhaps the easiest path forward would be for this court on its own initiative under Rule 60A to correct the record with respect. Now that the record has been developed, there is no dispute. The parties negotiated the release for Ms. Carlson. The fact is that, yes, her father, Rick, handed a check to the city. That is probably why the name Rick Carlson ended up on this document. But beyond all of that, I would also posit to Counsel for Apley's point at the beginning of his argument, what is the effect of that initial defective lien release?
Well, to that point, can I ask you this? I want to make sure I understand this. So the CJ number, which was correct,
Correct.
is that CJ number only governing Daisy?
Yes,
There's no other party that a judgment can be written to govern.
that is correct.
Okay, so if that's the case, seems like there's an argument that that was sort of like void, almost like a void ab initio.
Your Honor, you took the words from my mouth, is that if the initial lien was defective on its face, it had no effect.
Okay, so
Therefore,
it seems to me that there's an argument that even the decision of our court was incorrect in saying that this entry mooted out that particular assignment of error, because that entry was faulty and can only govern one party.
Your Honor, I am loath to say that this court was incorrect, but I do think that that decision was made in
So that
reliance
there's
on
an
an error.
argument.
Correct. There is an underlying error. There's no dispute. I signed my name to that piece of paper. That is my fault, but here we are. And we, the city, we do request that justice be done here.
Ma'am, let me ask you, since we mooted out Mr. Carlson's initial appeal, sort of cut off his rights based on the record we had, which said he had satisfied the judgment. What do we do now? Does he get another appeal?
Your Honor, I believe no, because each argument that was raised was addressed substantively by this court on behalf of all parties. So the trial court, in conjunction and collaboration with counsel for the city and Applee, we can work together to ensure that the judgments associated with each Carlson and the LLC are correct.
Thank you.
Your Honor, I have nothing more.
Okay, so unless there's any questions from the panel. All right, thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. And we wish you a wonderful afternoon and a great Turkey Day, which is this week.
You
Thank
too.
you, Your Honors.
Thank you. If council can please turn their cameras on.
Is Is mine turned on?
It is not. Neither camera is turned on, not for yourself nor for Attorney Kelly.
Is it turned on now?
It is not turned on.
Let me see what I can do.
Attorney Kelly? Okay,
It was turned on earlier.
okay. Well, we've also now lost Attorney Kelly.
Is it on now?
No, I guess it's not.
Well, it should turn it on.
Yeah.
I don't understand.
I'm going to pause.